Please be seated.
Your Honour, Commissioners, this is the Royal Commission's 54th case study. This public hearing will...
And repeat after me. I swear by Almighty God.
I swear by Almighty God.
Swear by Almighty God.
The evidence I shall give to this Royal Commission.
The evidence I shall give to this Royal Commission.
Shall be the truth.
Shall be the truth.
Shall be the truth.
The whole truth.
Whole truth.
And nothing but the truth.
Nothing but the truth.
Thank you. Take it. Yes, Mr. Chairman.
Mr. O'Brien, I'll start with you. Would you state your full names, your position in the organisation and your address?
Yes, my name is Terence John O'Brien. My position with the organisation, as you mentioned, I'm a director of the Watchtower Bible and Tract Society of Australia. I'm currently not serving as the coordinator of the branch committee in Australasia. I have an assignment in Papua New Guinea for 12 months, but I've kept up to date with the information to do with the Royal Commission. That's why I've come back for the hearing. So presently I reside in the branch facilities in Port Moresby in Papua New Guinea.
When did you cease having the responsibility of coordinator of the branch committee?
Beginning in October 2016.
And who is the current coordinator?
Name is Winston Payne.
Thank you. And Mr. Spinks, I'm coming to you. Would you state your full names, your position in the organisation?
Rodney Peter Spinks. I'm the Senior Service Desk Elder in the Service Department.
Can you explain what process Watchtower Australia went through in order to address the issues that had been raised?
So, as a branch committee, we considered the various issues as they applied to us as a branch committee, what areas of responsibility we could implement any suggested changes. As you would know, we had representatives from our world headquarters legal department here at case 29, and they returned with the case reports, and they've obviously looked at the reports in between. We've also since had members of our legal department here in Australia spend time at world headquarters. So many of these issues have been discussed, and that's where we are at present with them.
And I suppose you also identified what you regarded to be scriptural impediments to any changes.
Yes, that was part of the subject of discussion, but the scriptural content of any change that would be referred back to a different committee of the governing body. That's not something the branch committee would review.
Which committee of the governing body would that be?
Well, probably the teaching committee of the governing body.
And did the organisation in Australia take any external advice with regard to what procedures should be introduced or what changes should be made?
We considered the many reference materials that were provided to and by the Royal Commission. We reasoned that these are the ones with expertise that the Royal Commission has confidence in. So we've considered the various reports and case studies that were provided.
So if I'm to understand your answer correctly, you didn't take specific external expert advice with regard to changing your policies or procedures?
Not outside of what was presented to the Royal Commission, no.
Now, the upshot of that process you've described, as I understand it, is that initially at least 2 new documents were produced, one a guide to service desks and one a letter to elders. Is that correct?
Yes, that's correct.
So, if I understand this correctly, neither of these 2 documents go to ordinary congregants of the Jehovah's Witnesses. But leaving that document, that very recent document, to one side, is it the case then that insofar as the organisational response to allegations of child sexual abuse is concerned, ordinary congregants who are not elders and not deskmen, as they refer to as the service desk, would have regard to the publication organised to do Jehovah's will to find the organisational response.
Yes, although that document, whilst these two documents are specifically dealing with child abuse matters, the Organised to Do Jehovah's Will is a publication that has very little to do with child sexual abuse. It's basically talking about the general ministry of Jehovah's Witnesses.
Yes, I understand that. So still leaving aside the document of 7 March 2017, if a congregant wanted to know what processes there are that the organisation follows in the event that an allegation of child sexual abuse is raised, there's no specific policy document that they can have any access to, is that right?
No, leaving aside that document which now corrects that.
Yes. And so to the extent that they could learn anything about, for example, the two-witness rule or the judicial process within the organisation, they would be left with organised to do Jehovah's will.
No, I think the average member of a congregation has exhaustive references to what we call the Watchtower Library, and subjects such as those you've mentioned considered in Watchtower articles that everyone has access to.
And many of those going back over a long period of time.
And recent, yes, the most recent back to, I think, as far as 1930.
So by the recent ones, are you referring to articles referenced by you in your response and in your joint statement that have been published since case study 29?
Yes, some, but then there are other Watchtower study articles that are reviewed at congregation meetings which would contain other relevant information, but not specifically only dealing with the same as those reference materials, which are specific on child abuse.
So an ordinary congregant would have to go doing their own research through those various publications you've mentioned to find the answer on any particular topic related to child sexual abuse, is that right?
Yes, but the Watchtower Library is very much a user-friendly program which most of Jehovah's Witnesses have little trouble finding their way through.
Well, I think you accepted on the previous occasion, Mr. O'Brien, that there was an absolute need in the organisation to bring these policies and procedures together in an easily accessible place for congregants. You recall that?
Yes, which is what we've done.
And that's what's led to the 7 March 2017 document, is that right?
Yes, because now it's specifically dealing with child abuse matters.
Yes. So let's go to that then. At tab 11, there's a letter from the solicitors. Perhaps there isn't. In any event, that's the first document at tab 11 is a solicitor's letter dated 8 March 2017, which in the main paragraph says that we've been working on developing a policy statement of Jehovah's Witnesses in Australia in relation to child protection. As the final draft has only just been completed for distribution to congregations, we are pleased to provide a copy of the child safeguarding policy of Jehovah's Witnesses in Australia. And then that's the document that follows. Now, firstly, in relation to this document, has it yet been published or made available to congregants generally in Australia?
No, it's dated for release in March. It had been planned some time with the wanting to get it to the Royal Commission before this. I feel this is the final version. It has been approved now by the branch committee, it is an Australia document. It's not a worldwide document, so we've been able to give approval for that now. So we anticipate in the next week or so it will now be made available to congregations throughout Australia.
And when you say you got approval for it, that's from the World Headquarters or the governing body, is that right?
Yeah, a draft was obviously sent to the Coordinators Committee who look after legal matters for the worldwide field. But the Australia document here gained final approval by the Branch Committee for release.
When was it adopted by the Branch Committee?
Just this last week we've given the final version, the one that you have here.
You mean this week or do you mean last week?
No, this week we finalised the final edits on it, just a few minor edits.
Was there a meeting of the Branch Committee this week that approved and adopted this version?
I think the meeting was held previously. We would have just circulated it for final review, but it's only had a couple of minor edits to make on it.
And when did work on this document commence?
Well, I'm not sure on that. That's happened since my transfer to Papua New Guinea, but I think Mr. Spinks has been involved in that and he could give you a much better answer to the question.
Spinks?
So, immediately following the public hearing in case study 29, we went away with a clear picture, as did the representatives from headquarters here, that we needed to make some adjustments with documentation, which we incrementally did. So there's been a lot of discussion about this. It's actually based on a policy that was under development and issued for the UK, but obviously there are some different implications there. So it's been a drawn-out process, and towards the end we wanted to have it available for the Royal Commission. When our hearing date got brought forward, we have had to move quickly. We didn't send it to the congregations this week for the obvious reason that if there's a suggestion or discussion, we just wanted to reserve the right to make any minor adjustments before it's distributed. But it's taken some time, but we've actually brought it forward a little bit so we could present it to the Royal Commission.
And how long ago, Mr. Spinks, was it in a form similar to the one that we see now? In other words, leaving minor changes aside.
I'm not certain with regard to the UK, but I would think over the last 3 or 4 months there's been discussion and video conferences and that to get it into the shape that it's in. We wanted some specific inclusions, which we're glad have been included. We've referred to it as a living document that we want to make whatever adjustments need to be made to it, further adjustments if necessary, so that it's applicable for Australia.
Back to you, Mr. O'Brien. Is there any plan, to your knowledge, to revise, organise to do Jehovah's will, at least in relation to policies and procedures responding to child sexual abuse?
I'm unaware of any plans in that line.
Now, in relation to S66, so that's the guideline to service desks, I'd like to refer you to tab 12 itself, and the second bullet point you'll see it says that the letter of 1 August 2016, so that's the document we looked at earlier at tab 6, or 7 rather, will replace the letter dated October 1, 2012 to all bodies of elders. So I take it that's right, it replaces that earlier letter.
That's correct, yes.
So as of the date of the 1 August 2016 letter, the 1 October 2012 letter no longer applies.
That's true.
Right. And in the main paragraph in that letter, I don't intend reading it, but you'll see that much emphasis is placed on the confidentiality of the S66 document, and it says as to who specifically it can be given to. including that it's not to be given to service desk secretaries. Now, can you just explain what is I know this instruction didn't come from you, it came from World Headquarters, but I'm hoping you can assist us. What's the secrecy or confidentiality concern with regard to this guide to service desks?
Once again, I could defer to Mr. Spinks, who will give you a more accurate answer than what I'd be able to.
He works in the service desk. Yes, Mr. Spinks.
Again, I probably can't answer for the reason that it was written there, but I guess those of us on service desks have been given a heavy responsibility, as we see it, to ensure that we meld together the August 1 letter and the service desk guidelines. It's a responsibility we take very seriously in giving advice out. So my reading of it was simply that it's the responsibility of the service desk to make application of it and has ownership of the document. Beyond that, I couldn't comment.
Do you appreciate that someone from outside the organisation might struggle to understand why there should be such secrecy with regard to something which is a procedural document as to how matters should be handled procedurally? Do you see that?
I recognise that, and this came up in the earlier public hearing, that there's no doubt that some of our correspondence, it's well understood by the audience it's intended for, but read from a critical perspective, and we appreciate that, that it could be seen that way. Our understanding of it, or our application of it, is the elders have a letter that applies to their function and role. The service desks have guidelines that are specific to their function and role, and there's some reasonable amount of discretion required in the application of that on a case-by-case basis. But I take your point.
See, it might leave someone with the impression that there's really a dual practice here, that congregants are being kept from information which, with regard to processes that govern their lives or govern issues that arise in their lives. Do you see that?
I understand that criticism that has been made. From our perspective, it's audience specific. The instructions are there for a service desk to make application of it. Again, I take your point.
Now, Mr. Spinks, you say, both of you in your statement, that the Jehovah's Witnesses teach that child sexual abuse is an abhorrent sin. That's right, isn't it?
That's correct.
And it's that teaching of the Jehovah's Witnesses that you rely on as an important element of your strategy to make the organisation a child-safe organisation. Is that right?
That, and making sure that we conform with whatever legal requirements there are. We've taken the recommendations of the Royal Commission seriously.
Mr. Spinks, I said it's an important element. And what I'm saying is one of the things you say with regard to what you do to make your organisation child safe is that you teach Jehovah's Witnesses that child sexual abuse is an abhorrent sin. Is that right?
That's correct.
Yes. And of course, just what child sexual abuse is in the eyes and in the teaching of the organisation is therefore important. Do you accept that?
Yes.
And to the Royal Commission, child sexual abuse includes sexual or sexualised activity by an adult with anyone under the age of consent. Do you accept that?
Yes.
Now, I'd like to refer you to the letter to elders at tab 7 and seek your clarification with regard to something. In particular, if on page 2 you would look at paragraph 10, which is headed Congregation Considerations, and you'll see some distinctions are drawn. And in particular, the sentence I want to ask you about is the last sentence, but by all means read the whole lot. And the last sentence says, rather, this is in relation to what is child sexual abuse, we are referring to an adult guilty of sexually abusing a minor who is a young child. I don't think there's any question about that. And it goes on, or an adult guilty of sexual involvement with a minor who is approaching adulthood but was not a willing participant. Now, the question there is really this. This seems to be saying that within the eyes of the organisation and teaching of the organisation, a minor consenting to sexual involvement with an adult, a more mature minor, or as it's put here, a minor who is approaching adulthood, is not regarded as child sexual abuse.
No, that's not correct. That's not the intent of that, and if I could briefly explain.
Yes, so what I'm getting at is to understand the organisation's teaching or understanding as to where the line is drawn with regard to looking at the question of age or majority, where the line is drawn with regard to what is child sexual abuse.
I think if you go back to earlier in the paragraph, if I could, to give that context, and remembering that this is in addition to whatever legal implication. This is a congregation consideration. It says, when discussing child sexual abuse from a congregation standpoint, we're not discussing a situation in which a minor who is a willing participant and who is approaching adulthood is involved in sexual activity with an adult who is a few years older than the minor. So while that's a broad expression, our experience has been, for example, where we have seen it as child sexual abuse. One of the reports that we provided to the Royal Commission, where we viewed it that way, the elders have reported it that way, but the authorities don't necessarily view it that way, where the age gap is close. So that's not to be interpreted to say if the minor is willing. There are situations where, for example, a 19-year-old and a 16-year-old may have a consensual relationship. Now, there may be an implication under law, there may not. The same with the congregation. Were these close ages and consensual, or was the age gap such that there's either a legal implication or a congregation implication?
So basically you're saying is that final sentence must be read as qualified by the first sentence. It's talking about two people relatively close in age.
Correct.
Right.
What is understood by a participant who is approaching adulthood? What does that mean?
For example, Your Honour, there may be a 16-year-old whose age of consent, and we're not, while we promote high moral standards, we're not so naive as to think that 16 and 18-year-olds aren't having sex. So we appreciate that there are circumstances where you've got two consenting people. One is technically by law an adult, one is approaching adulthood. So it's in that context.
Again, ask you, what do you understand to be someone approaching adulthood?
That was the example I used, Your Honour, where...
16-year-old?
Well, not necessarily.
That's what I'm trying to find out.
Well, I think the law is probably clear to us on that. For example, a 16-year-old may be able to consent. And so, again, if it was a 16 and an 18-year-old, we are not talking about here young teenagers with adults. We're talking about where there's a similar age.
I understand what you're talking about. I'm still trying to find out what you understand to be a participant approaching adulthood.
It would always be someone of a close age to 18, Your Honour. That's our understanding. You know, that's how we view it, taking into account the whatever legal implications there are too.
So it wouldn't include a 16-year-old in your understanding?
I did mention the example that the law would permit a 16-year-old in some states to have sex with an 18-year-old. We're not going to necessarily view it differently if they're of if it's a consensual relationship between a 16-year-old and an 18-year-old.
Well, let's test it further. What about a 15-year-old?
I think in most cases the law would have an implication there as well that we would take into account. And each situation, we would get legal advice, but also make a determination, is this two young people of a similar age that have a consensual relationship, or is one using his, for example, authority or older age to take advantage of the younger person?
Well, the difficulty, Mr. Spence, that you face, isn't it, is that according to your teachings, the Bible doesn't specify an age as to when one reaches adulthood.
That's correct.
And I suppose in ancient times, and you'll correct me if I'm wrong, it may have been at the time that the scriptures were written that someone in modern times would be regarded as very young, like a 13, 14-year-old might be able to marry. Would that be right?
Certainly not in the Bible. Thank you for... I appreciate that is the case in some cultures, but the Bible teaches very clearly that it would be someone who's past youth. But your point is taken, that there's no strict rule in the scriptures.
Well, but that leaves us to the question of when is past youth?
I probably am not understanding your question. I don't want to be evasive because, again, we've had, and I'll be very happy to provide the details of this to the Commission, we've had situations recently because of our heightened sense of awareness of these issues where the elders have taken a young couple, one recently in Victoria where the girl was 15 and the young man was in his early 20s. They're from a culture outside Australia, courting young. They were obligated under law to go to the police. The elders went with the family to interpret, and the police said in that instance that they didn't view it as a sexual assault of the minor. So there are complications. From a congregation point of view, we probably have a stricter view than the law.
Mr. Spence, I don't want to spend time on it. The simple point is this, is the law, perhaps for reasons of pragmatism as much as anything else, and draws clear lines between when one can consent and when one can't consent legally to sexual intercourse, whereas the Jehovah's Witnesses don't. And would it not make your approach to things a lot easier and a lot clearer if you just followed the clear lines of the law in relation to this?
That's a complete misunderstanding. I apologise, Mr. Stewart. This is a secondary consideration to the law. Jehovah's Witnesses will always abide by the law. So this expression relates to where the law doesn't have an implication. The congregation may still view it as child sexual abuse or not, but it's always secondary to the law. So I can't see a situation where that would occur.
You say, both of you in your statement, that the Jehovah's Witnesses teach that child sexual abuse is an abhorrent sin. That's right, isn't it?
That's correct.
And it's that teaching of the Jehovah's Witnesses that you rely on as an important element of your strategy to make the organisation a child-safe organisation. Is that right?
That and making sure that we conform with whatever legal requirements there are. We've taken the recommendations of the Royal Commission seriously.
Mr. Spinks, I said it's an important element. And what I'm saying is one of the things you say with regard to what you do to make your organisation child safe is that you teach Jehovah's Witnesses that child sexual abuse is an abhorrent sin. Is that right?
That's correct.
Yes. And of course, just what child sexual abuse is in the eyes and in the teaching of the organisation is therefore important. Do you accept that?
Yes.
And to the Royal Commission, child sexual abuse includes sexual or sexualised activity by an adult with anyone under the age of consent. Do you accept that?
Yes.
Now, I'd like to refer you to the letter to elders at tab 7 and seek your clarification with regard to something. In particular, if on page 2 you would look at 10. Which is headed Congregation Considerations. And you'll see some distinctions are drawn. And in particular, the sentence I want to ask you about is the last sentence, but by all means read the whole lot. And the last sentence says, rather, this is in relation to what is child sexual abuse, we are referring to an adult guilty of sexually abusing a minor who is a young child. I don't think there's any question about that. And it goes on, or an adult guilty of sexual involvement with a minor who is approaching adulthood but was not a willing participant. Now, the question there is really this. This seems to be saying that within the eyes of the organisation and teaching of the organisation, a minor consenting to sexual involvement with an adult, a more mature minor, or as it's put here, a minor who is approaching adulthood, is not regarded as child sexual abuse.
No, that's not correct. That's not the intent of that, and if I could briefly explain.
Yes, so what I'm getting at is to understand the organisation's teaching or understanding as to where the line is drawn with regard to looking at the question of age or majority, where the line is drawn with regard to what is child sexual abuse.
I think if you go back to earlier in the paragraph, if I could, to give that context, and remembering that this is in addition to whatever legal implication. This is a congregation consideration. It says, when discussing child sexual abuse from a congregation standpoint, we're not discussing a situation in which a minor who is a willing participant and who is approaching adulthood is involved in sexual activity with an adult who is a few years older than the minor. So while that's a broad expression, our experience has been, for example, where we have seen it as child sexual abuse. One of the reports that we provided to the Royal Commission, where we viewed it that way, the elders have reported it that way, but the authorities don't necessarily view it that way, where the age gap is close. So that's not to be interpreted to say if the minor is willing. There are situations where, for example, a 19-year-old and a 16-year-old may have a consensual relationship. Now, there may be an implication under law, there may not. The same with the congregation. Were these close ages and consensual, or was the age gap such that there's either a legal implication or a congregation implication?
So basically you're saying is that final sentence must be read as qualified by the first sentence. It's talking about two people relatively close in age.
Correct.
Right.
What is understood by a participant who is approaching adulthood? What does that mean?
For example, Your Honour, there may be a 16-year-old whose age of consent, and we're not, while we promote high moral standards, we're not so naive as to think that 16 and 18-year-olds aren't having sex. So we appreciate that there are circumstances where you've got two consenting people. One is technically by law an adult, one is approaching adulthood. So it's in that context.
Again, ask you, what do you understand to be someone approaching adulthood?
That was the example I used, Your Honour, where...
16-year-old?
Well, not necessarily.
That's what I'm trying to find out.
Well, I think the law is probably clear to us on that. For example, a 16-year-old may be able to consent. And so, again, if it was a 16 and an 18-year-old, we are not talking about here young teenagers with adults. We're talking about where there's a similar age.
I understand what you're talking about. I'm still trying to find out what you understand to be a participant approaching adulthood.
It would always be someone of a close age to 18, Your Honour. That's our understanding. You know, that's how we view it, taking into account whatever legal implications there are too.
So it wouldn't include a 16-year-old in your understanding?
I did mention the example that the law would permit a 16-year-old in some states to have sex with an 18-year-old. We're not going to necessarily view it differently if they're if it's a consensual relationship between a 16-year-old and an 18-year-old.
Well, let's test it further. What about a 15-year-old?
I think in most cases the law would have an implication there as well that we would take into account. And each situation we would get legal advice, but also make a determination: is this two young people of a similar age that have a consensual relationship, or is one using his, for example, authority or older age to take advantage of the younger person?
Well, the difficulty, Mr. Spence, that you face, isn't it, is that according to your teachings, the Bible doesn't specify an age as to when one reaches adulthood.
That's correct.
And I suppose in ancient times, and you'll correct me if I'm wrong, it may have been at the time that the scriptures were written that someone in modern times would be regarded as very young, like a 13, 14-year-old might be able to marry. Would that be right?
Certainly not in the Bible. Thank you for... I appreciate that is the case in some cultures, but the Bible teaches very clearly that it would be someone who's past youth. But your point is taken, that there's no strict rule in the scriptures.
Well, but that leaves us to the question of when is past youth?
I probably am not understanding your question. I don't want to be evasive because, again, we've had, and I'll be very happy to provide the details of this to the Commission, we've had situations recently because of our heightened sense of awareness of these issues where the elders have taken a young couple, one recently in Victoria where the girl was 15 and the young man was in his early 20s. They're from a culture outside Australia, courting young. They were obligated under law to go to the police. The elders went with the family to interpret, and the police said in that instance that they didn't view it as a sexual assault of the minor. So there are complications. From a congregation point of view, we probably have a stricter view than the law.
Mr. Spence, I don't want to spend time on it. The simple point is this, is the law, perhaps for reasons of pragmatism as much as anything else, and draws clear lines between when one can consent and when one can't consent legally to sexual intercourse, whereas the Jehovah's Witnesses don't. And would it not make your approach to things a lot easier and a lot clearer if you just followed the clear lines of the law in relation to this?
That's a complete misunderstanding. I apologise, Mr. Stewart. This is a secondary consideration to the law. Jehovah's Witnesses will always abide by the law. So this expression relates to where the law doesn't have an implication. The congregation may still view it as child sexual abuse or not, but it's always secondary to the law. So I can't see a situation where that would occur.
Just in relation to the specific legal advice, there are various errors that occur in these documents. I'll just take you to two to demonstrate them and then leave you with, hopefully you'll agree, with an acceptance that they need to be looked at again. If we go to tab 14, which is headed Reporting Obligations in Queensland. And you'll see that it says the age of consent is 16 for heterosexuals and 18 for homosexual. Do you see that?
Yes.
Now, firstly, are you aware that the law in Queensland in relation to age of consent changed last year?
I'm not. If this is inaccurate, then that needs to be addressed, but I wasn't aware of that.
Well, it's inaccurate in that respect. It's inaccurate in another, and that's that it's 16. There's no longer a distinction, and it's inaccurate in another respect, and that is that the law draws no distinction, or drew no distinction prior to change, and subsequently between heterosexuals and homosexuals. In other words, the age of consent at 18 was set for anal intercourse, man or a woman. You're not aware of that?
No, obviously, I see there's a reference there, Mr. Stewart. The criminal code is not attached, but I wouldn't be able to interpret it anyway. But if that's incorrect, then I'm happy to report that back and have that adjusted.
Right, going on now to address the two-witness rule. Mr. O'Brien, you're aware, of course, the Royal Commission found that the application of the two-witness rule in cases involving child sexual abuse is wrong. You're aware of that finding?
Yes, I'm aware of the finding.
And the recommendation that the Jehovah's Witness organisation should revise and modify its application of the two-witness rule, at least in cases involving complaints of child sexual abuse. You're aware of that recommendation?
Yes, I'm aware.
And I take it that that finding and that recommendation were the subject of the discussions you referred to earlier in the organisation with regard to its response to the Royal Commission.
Yes, so we considered the implications of that finding.
And your response is to say that the two-witness rule is required by the scriptures and can't be changed or avoided. Is that correct?
That's correct. That's our stand.
And Your Honour, I'm not sure what Your Honour's intention was.
How much longer will you be?
Well, I'll take us till 1 o'clock, Your Honour.
Well, we better take the morning adjournment then. We'll take that adjournment now.
I'm just dealing with the two-witness rule, you'll recall, and I'd like to take you to your response document, Mr. O'Brien, at tab 1, page 14, paragraph 7.4. Where you set out, you say, moreover, it should be noted that sufficient scriptural evidence to establish a serious sin may consist of two or more witnesses to the same sin, or two or more witnesses to the same type of sin committed on different occasions. So the rule, in the absence of a confession, requires corroboration of an allegation. Is that right?
That's correct scripturally.
Yes, and a particular type of corroboration being another witness or, as it's put here, another witness to a different occasion of a similar type of sin. Is that right?
That's how I understand it, yes.
And then you go on and you say, on this basis, the scriptural rule of evidence as applied by Jehovah's Witnesses is already in harmony with the model bill, evidence, tendency, and coincidence model provisions by admitting tendency or coincidence evidence when establishing sin in their ecclesiastical proceedings. Now, leaving aside the admission of evidence, let's just deal with this question of corroboration. You're aware, I take it, that the criminal courts do not require corroboration of child sexual abuse or indeed the most heinous of sins.
Yes, I'm not clear on that particular point.
I'll ask you to accept
but I'll
that.
take your word for it.
Section 164 of the Evidence Act abolished the corroboration rule. So it's just misleading to say that this scriptural rule of two-witness rule is in harmony with the law of evidence. It's not in any way, is it?
I would defer to your knowledge of the law on that.
Mr. Jeffrey Jackson of the governing body gave evidence in case study 29, suggesting that there may be a role for circumstantial or corroborating evidence, such as the evident trauma suffered by a victim, in determining the truth of an allegation. For those who are following, that's at transcript 15973, starting at line 37. Now, subsequent to case study 29, the rule has not been modified so as to allow circumstantial or corroborating evidence such as evident trauma suffered by a victim. Was that nevertheless considered?
I'm sure Mr. Jackson would have taken that back to for consideration in the United States, but I'm not aware of discussions on the particular point.
So we too deduce, I take it, that he was wrong in saying that there may be a role for such evidence, that it turned out there isn't a role for such evidence. Was that right?
I couldn't answer that on behalf of Mr. Jackson, sorry.
Now, if you go to the service desk guidelines at tab 6, paragraph 8, you'll see that it says there, for an accusation of serious wrongdoing to be established from a scriptural standpoint, there must be sufficient scriptural evidence, either a confession or testimony from 2 credible witnesses. Now, you'll accept, of course, that what's not included in the statement of the rule there is the additional component to it, which you speak to, which is admissibility of another witness to a separate incident of the same type of wrongdoing.
So that would be understood, that our policy on 2 witnesses.
So one has a statement here to guide the service desk, but it doesn't state the second component to the rule.
If I could, Mr. Stewart.
Yes, Mr. Spinks.
Without looking it up there, but paragraph 8 references KS10, which is the Elders Shepherding Manual, and those paragraphs referred to there specifically state those points. So confession.
Well, yes, I'm aware of that, but so it's there, but one has to go to another document to find it. Is that your point?
I think if I could, by way of example, again, it's about audience, Mr. Stewart, the service desks know that KS10 well, so we understand that somebody else looking in would say that's the case, but if I could, by way of example, I've done my best to read almost every issue paper and report from the Royal Commission, and hundreds of hours of wading through, and there's invariably a executive summary. Now, I'm not using this as a direct parallel, but this is simply an outline, an overview. The extracts of all those publications are not put in there, but that reference, could I refer to it in the KS10?
Yes, well, I've got it here. It's at tab 9, ringtail 75 at the foot of the page. It states what we've just spoken about. If there are 2 or 3 witnesses to the same kind of wrongdoing, but each one is witness to a separate incident, the elders can consider their testimony. That's what you're referring to?
Correct.
Yes. Well, where you refer to this in your joint statement, let me take you to that. Tab 2, paragraph 26. So that's on page ringtail 7. Paragraph 26, the second sentence, however, in the absence of a confession of more than one witness to a single incident, the scriptural rule of evidence establishes and allows the admissibility of another witness to a separate instance of the same wrongdoing. And you see you have footnote 15 there, and it references 3 different documents. Do you see that?
Yes.
And the third of those documents, which is the one which has ringtail WAT 0001004068 at paragraph 11. I beg your pardon. The middle of those documents is the KS10, the Shepherd book.
Correct.
Correct. At the paragraph we were looking at a minute ago, paragraph
Correct.
37. Yes. But the first of those documents is a 1991 document. Pay attention to yourselves and all the flock. Is that right?
But I have no reason to doubt that. I haven't got that.
And the 1991 document is of the nature of a document that goes to all the congregations, all the congregants. Is that right?
I'd need to see the document. I have no reason to question what you're saying.
You'll be familiar with the document. It's the 1991. Pay attention to yourselves and all the flock.
I am familiar with that publication.
So is that for elders or for congregants?
For elders.
For elders, right. And the current elders document is the Shepherd document 2010, not so?
Correct.
So the 1991 document you reference is an out-of-date document?
that was superseded. The Shepherd manual superseded. That was a previous version.
Yes. So in January, I beg your pardon, February the 24th, when you sign the statement, you give an old superseded reference.
Followed by the current reference, and I believe the purpose at the time was to show a consistent process there. I mean, if you put the two together, you'll find it similar, but I don't have it in front of me.
And the third reference you give is the 1 October 2012 letter, which was replaced by the 1 August 2016 letter.
Correct.
And the August 2016 letter doesn't state this rule in this fashion. You see, Mr. Spinks, we're back to where we were in case study 29, of really struggling with just what the position is, because there's so many different conflicting documents, and we're given documents which have been superseded as authority for what's said to be current policy.
Well, Mr. Stewart, that's just incorrect.
Well, please
let me take you back to paragraph 8 again, if I could.
Paragraph 8 of what?
Of the guidelines for service tests?
Yes. That's tab 6.
Current guidelines, current reference, KS 10, Chapter 5 is the shepherding textbook. I take your point that when you're reading a statement, we've provided historical background, but I recall in the preparation of that was to overcome what we thought would be an obvious objection, that's not always been the case. But the latest reference is in the footnote there, and it certainly is in the paragraph 8 of the service desk guidelines. Now, if the suggestion is that every one of those extracts should be pasted into the document, we'd be happy to consider that. But again, we're extremely familiar with that source material, and it's there in the current letter.
Well, the suggestion is that you reference out-of-date and superseded policies in support of your statement as to what the current policy is.
Mr. Stewart, again, with respect, I've just very clearly explained that the reason for that, the current policy is there, and to address what we felt would have been an obvious objection from the Commission that hadn't previously been our policy. So that's simply a footnote reference to show the existence of the policy.
Dealing with the subject of a victim having to confront the abuser, you know, of course, that the Royal Commission found that the Jehovah's Witness written policies and procedures should clearly state that it is not a requirement in cases of child sexual abuse the victim must confront her alleged abuser. You know that?
Yes.
And that it was recommended that members of the organisation more generally should be advised in writing of the specific exemption that applies in cases of child sexual abuse. You're aware of that?
Yes.
And the letters to elders now make it clear that this is not required. Is that right?
That's correct.
Paragraph 13.
That's correct.
Yes. And but not the service desk guidelines. Am I right? Or have I overlooked it?
I'd have to just give me a moment. Thank you. I'd have to just give me a moment. Thank you. Wider audience. The August 1 letter is to all elders and obviously service desks. So there's quite a few examples of where the same items are not repeated in the service desk guidelines. All the service desks, by the way, and secretaries have those two items bound together because we read them together.
Now, on the specific point, this point of victim having a right not to have to face the abuser, which is, as I've said, clarified in the 1 August letter. It's also clarified in the 7 March policy.
Correct.
But it's not been addressed in the Shepherd book, has it?
those words, no. There was lengthy discussion at the original hearing where we went to the KS textbook and looked at what was a few brief expressions in the context of dealing with allegations in general, but I don't believe that same wording is exactly transposed into the KS10, which I think, as we've made aware to the Commission, is actually partway through editing as we speak. We provided the Commission with the adjustments that have been made to date, and we're expecting that there'll be an entire adjustment of that and made available to all elders. But it's certainly much clearer in the documents.
I must think so. That is new to me at least. So let's just unpack that. Firstly, you've made available to us, which is now tab 9, a copy of the 2010 Shepherd the Flock of God, which is also referred to as KS10, with marginal annotations referring to certain letters to elders and other documents. That's right, isn't it?
Correct.
Right. But no actual changes to the substantive text. But if one goes to the letters, one can see where the text might have been qualified.
And I believe on your copy there as well, those are marked beside it, and that's been distributed to every elder around the world. It's actually a live document electronically now where, as those changes are being made to that book, they're made live to every congregation elder. So we've simply given you a PDF version of the live copy.
Yes, I understand that. But now the actual text of this document, am I to understand what you've just said now, is that it's in a current process of revision, and there's expected to be a new Shepherd the Flock of God edition to be produced? That's
my understanding, and that's the reason for these ongoing edits. So I would anticipate that while that is referred to in the shepherding manual, I'm happy to go there again as we did at the previous hearing, but it will certainly be clearer using the language of the current policy in any future edition.
Well, I do wish to go there. It's at tab 9, ringtail 0076, type page 72, paragraph 39. Now, accepting that this is not dealing specifically with child sexual abuse, it's dealing with serious sin generally, that's right, isn't it?
That's correct.
It says that under the heading, if the accused denies the accusation, the investigating elders should try to arrange a meeting with him and the accuser together. And then there's a note, if the accusation involves child sexual abuse and the victim is currently a minor, the elders should contact the branch office before arranging a meeting with the child and the alleged abuser. And that would then be to the service desk.
That's correct.
Yeah, and it's the service desk guidelines which, unlike the letter to elders, that don't have the position clearly stated that a victim has a right not to have to face her accuser.
So the service desk guidelines are very clear on that. And if I could just have one moment, please, Mr. Stewart. If I could, apologise if I'm repeating something that you've clearly stated here, but in the August 1, 2016 letter protecting minors from abuse, on paragraph 13.
Yes, but that's the letter to elders.
Correct.
Yes, so I've just addressed not that letter, but the guidelines to the service desk, which is where the elders here in paragraph 39 are referred to. They're referred to the service desk.
Correct.
Yeah, and the guideline to the service desk doesn't contain an articulation of this right.
As I said to you in the letter, the
letter to the elders contains.
Sorry, if I could, Mr. Stewart, read to you paragraph 1 of the service desk guidelines.
Yes.
It says the August 1, 2016 letter to all bodies of elders provides direction in connection with protecting children from abuse, the service desk should be thoroughly familiar with that letter and pertinent information in the shepherding textbook. So again, it's audience. The letter is for all elders. The service desk guidelines are for the service desks.
So I accept Mr. Spinks, you say you know that and it therefore doesn't have to be in the guidelines. Not so.
Well, it is in the guidelines in that.
By reference.
Well, the letter is attached. There are two documents side by side that we use together.
Yes, now, Mr. Spinks, going on to the next sentence at paragraph 39 of Shepherd. If the accuser or the accused is unwilling to meet with the elders, or if the accused continues to deny the accusation of a single witness and the wrongdoing is not established, so I take it not established scripturally, i.e. under the two-witness rule, would that be right?
That's correct.
The elders will leave matters in Jehovah's hands. So the result of that is this, isn't it? And I think it's stated in a recent policy document, that even if someone who's accused of child sexual abuse is convicted beyond a reasonable doubt by a criminal court, if the scriptural rule of evidence, the two-witness rule, is not met within the Jehovah's Witnesses' internal processes, then the matter is left in Jehovah's hands.
That's, again, totally incorrect, and I apologise for being direct with it, Mr. Stewart, but, and I'm sure it's unintentional, but you are, and the transcript will show, we've had this lengthy discussion at the first hearing. If I could be permitted to say, that bracketed section, you've gone on and read the part after it, the bracketed section is inserted there to say, when it relates to child sexual abuse, contact the branch, end of bracket. It now continues with what would be the normal judicial process that is perfectly clear to elders. I appreciate, again, it's about audience, but the bit that you read after that is not stating with regard to child sexual abuse. And in addition, you've added into the end of that statement that you just made that regardless of what the secular authorities would do, that wouldn't permit the congregation to act, when the documentation shows that's just completely incorrect.
Well, the documentation says that the service desk may then impose restrictions.
And can I, again, appreciate the different audience, Mr. Stewart, but can I say to you that that does not relate, for example, to a person in a position of responsibility. This is, as you would refer to them, meeting attendants or attenders or congregation members. But in every case, steps are taken where the authorities are involved. There'd be no individual who's continuing, for example, in a position of responsibility where the secular authorities have established guilt. That situation doesn't exist.
Do you have a system of monitoring compliance with that right? In other words, the right of the victim not to have to face her abuser?
Yes.
What is your system of monitoring?
In every situation, as set out in these documents, and as you've stated yourself, the elders call the legal department, they call the service department, and in every case those key issues are repeated, and now of course in the more publicly available document.
Now, Mr. O'Brien, you're aware that the Royal Commission found that members of the organisation who no longer want to be subject to its rules and discipline have no alternative but to actively leave or disassociate from the organisation, and that it found that the Jehovah's Witnesses' practice of shunning members who disassociate from the organisation potentially put survivors in the untenable position of having to choose between constant re-traumatisation and having to share a community with their abuser or losing their entire community. So those are two findings of the Case Study 29 report. You're aware of those findings?
Yes, I'm aware of the findings, but I think we disagreed with the findings. Respectfully, I can say that. I think Mr. Jackson, in his testimony, made the same point, as I did in my testimony, that we don't believe it's an impossible choice. A person can stop associating with Jehovah's Witnesses, have nothing more to do with Jehovah's Witnesses without taking the step of disassociation. We've tried to make that very clear.
Yeah, well, I'm not going to go back down that path now, having exhausted it on a previous occasion, but what I expect to find is the organisation's response to these findings in your response document of 3 January 2017. Would that be right? That's where we should go to, is that right?
That's correct, yes.
Yes. And so if we look at that document at tab 1, page 16, which is ringtail 31. I'm right at the foot of the page, 7.14.
Our January document, is it?
Do you have that?
Just the January document?
Yes.
7.14.
So you say there in the first sentence, shunning a disfellowship child molester is and will continue to be Jehovah's Witness Bible-based response to this serious sin. Well, that depends, of course, on whether the person was disfellowshipped or reproved, doesn't it? If they were reproved, then they're not shunned.
Yes, that's correct. But here it's talking about the child molester. If they
who is disfellowshipped, I beg your pardon, who is disfellowshipped. But if they're not disfellowshipped, then they're not shunned. Right?
No.
Right, and then goes on, this practice is an effective mechanism for protecting children in the congregation. Well, of course, I think we canvassed before that doesn't do anything for children outside the congregation. Would that be right?
Well, that's a position that's been taken, but again, we say that the congregation arrangement is one to protect the congregation from sin. We judge the matter of sin. We're not in competition with the legal justice system, and I think we've been down the road a little earlier that with reporting, we'll report out if it was mandatory reporting. That's a completely separate issue. If it's not, then we will leave that to the parent or the victim. But certainly...
So, Mr. Ryan, that's the first of the 3 paragraphs response. We go to the next one, 7.15. You say it is not and has never been Jehovah's Witnesses' policy to shun a victim of child sexual abuse. So that says what it says. That's fine. That doesn't meet the point that's being made, which is the victim of child sexual abuse who wants to and does leave the organisation is shunned. And then 16 says the policies and procedures on how elders should respond to victims have been consolidated and clarified. Elders have been reminded and encouraged to be empathetic and compassionate to their victims and their families. They've also been directed to provide ongoing shepherding to comfort both the victim and his whole family. If the elders are approached by a survivor of child sexual abuse, they should speak consolingly to the person and manifest an empathetic, compassionate, patient and supportive response. In exhorting congregation elders to lovingly and kindly serve as spiritual shepherds to victims of child sexual abuse, Jehovah's Witnesses confirm their long-standing policy that a victim will not be shunned. But and I suggest to you none of that answers the point being that it's particularly damaging when a child sexual abuse victim leaves the organisation, disassociates from the organisation and is then shunned.
Well, that would be true if they disassociate themselves, you're referring to.
Yes.
Because that is the policy. But again, I think, as I pointed out in my evidence, I think Mr Jackson did as well, that here we're talking about somebody who is of an age where they have qualified for baptism. So they are somebody who's either approaching adulthood or an adult, making that decision, understanding the implications of choosing either to disassociate themselves, knowing the consequences will be shunning, or simply ceasing activity with the congregation, but not taking the stand of disassociation. So it's a choice on the part of the person.
Well, in brief, what you're saying is you haven't changed in response to the Royal Commission report in case study 29, you haven't changed anything in relation to shunning, is that right?
Could I just read one scriptural point, because not all of the commissioners were here for the hearing, and I think this is really the basis for our thinking on these scriptural matters on which we find disagreement. So we appreciate there's disagreement. This is in the Bible book of Isaiah, chapter 33, and it talks about the laws under which Jehovah's Witnesses believe we come. Chapter 33, verse 22, it says, "For Jehovah is our judge, Jehovah is our lawgiver, Jehovah is our king." So that covers every aspect of the legislative, the executive, the judicial process. All Jehovah God reserves to himself. And we understand scripturally he delegates some of that authority to congregations, to families, husbands, wives, parents. But ultimately, if God's word provides a direction on a certain doctrine, Jehovah's Witnesses are bound by that, regardless of how others may view that.
Well, I understand that's the position you take, and I'm not going to enter into a debate with you about how, as I did on the previous occasion, about how the Jehovah's Witnesses' position on a range of things has changed over the years, on blood transfusions and blood fractions, by way of example, and on a number of other things. So we'll leave all that to one side. But just to get back to my question, which I understand the answer is yes, and the question was, in response to the Royal Commission findings and recommendations in relation to shunning in the report for case study 29, you've not made any changes?
Well, the branch committee or the directors of the Watchtower Bulb and Track Society of Australia are not authorised to be able to do that, Mr Stewart. That was a matter Mr Jackson would have taken back to the governing body, as he said he would.
Yes, that's the point that you make, is you regard yourself bound by those policies, or to those policies by the scriptures, and you can't change them, and therefore haven't changed them. Is that right?
Scriptural understanding, most definitely.
Could I comment, Mr Stewart?
Yes, Mr Spinks.
I think, and again, if it's about how it's presented, we accept that. It's not our intention to be defensive, but Councillor Sisting is repeating what was an incorrect conclusion from our perspective, and I say that with respect, where you're actually asking, have Jehovah's Witnesses changed something that they never did? So I think where the confusion comes in, and Mr O'Brien has nicely explained that if somebody chooses to take a different course and remove themselves, disassociated, that's a matter for them. But victims of child sexual abuse are not shunned. There's no evidence.
Unless they disassociate, then they are. That's the point.
Well, but again, what you're suggesting there is that the congregation makes a decision to shun a victim. If a victim or a survivor makes that decision themselves, then they understand the implications. There's not a situation where someone has disassociated because they're a victim of child sexual abuse, but we just wanted to make that point again.
I think the real issue is that for some people, the circumstances will be such that they just can't stay, and they will find it necessary for their own survival, effectively, to disassociate. But the consequence of that is they are shunned and lose all of their prior social structure. That's the issue, and you heard the evidence that some people gave about that issue. That's the problem.
If I could, Your Honour, with respect...
That doesn't happen in other parts of society, generally.
Again, Your Honour, with respect, and I certainly don't want to be protesting the point.
Say what you believe to be true.
Thank you for that. The Commission has consistently, and we respect the right of the Commission to draw the conclusions, and Councillor Sisting, but the Commission has consistently failed to acknowledge that individuals who want to leave the organisation of Jehovah's Witnesses, no longer be an active member, can do that by conflating someone choosing to no longer be an active member and someone specifically disassociating themselves, saying, I just don't agree with the organisation anymore, I don't want to be a part of it, are two totally separate things. And again, with respect, we just make the point
that was inherent in what I just put to you, but the consequence of dissociation, as we understand it, is that that person will be shunned, and that means they lose contact with family, friends and everyone else who remains inside the Jehovah's Witness organisation. Is that right?
Again, Your Honour, the person...
Your colleague is nodding. Is that right or not?
Well, because you've said disassociated, Your Honour, but he or she can choose to be no longer an active member of the congregation.
I understand that, but if they are so unable to cope with what's happened and the way they've been treated inside the organisation, that they dissociate, then they lose all of their previous social structure. Is that right?
That could be the case, and we respect their right to make that decision.
Well, it's a pretty cruel way of dealing with someone, isn't it, who has suffered sexual abuse.
I could only repeat what I've said, Your Honour.
No, but it's cruel, isn't it? To take away, by reason of the rules that you impose, all of their social structure. That's cruel.
Could I just interrupt, Your Honour? I believe with the difference between disfellowshipping and disassociation, the congregation takes the action in disfellowshipping somebody who is then shunned. The person who disassociates himself, they're taking the action. Now, for whatever reason, I agree, not even with regards to being a victim, others make the same decision. But they are actually taking the stand to shun the congregation from themselves. And they understand the implications of that. Now, it is, I agree, it puts them in a difficult situation, but it is a choice.
You see, someone who comes to you and says, I was sexually abused, but because there's no two witnesses, you don't accept it. You don't make that finding. They're left in a very difficult position, aren't they?
If they choose not to report it to the authorities, then...
For whatever reason, if the organisation doesn't acknowledge that they were abused, that imposes a great burden on them, doesn't it?
If I could again respectfully say, Your Honour, we don't disbelieve a person who makes an accusation. That's why we investigate every accusation brought forth by the elders.
Yes, but if there's not two witnesses, you don't accept it, do you?
Because scripturally we're not able to.
I know. And that, you would understand, can be very, very distressing for someone who has come to you with that complaint, can't it?
Certainly. Not being a victim is very distressing. Whatever consequences come, yeah, we agree.
And that can lead to a chain of circumstances where that person feels unable to do other than dissociate from your organisation.
Could I respectfully, Your Honour, say we don't want to be defensive, and we acknowledge that disassociation or disfellowshipping certainly have implications. An individual can choose to be inactive. Could I use very briefly a parallel that in my careful reading of the issue papers from the Commission, and some of it I don't understand, most of it I have, it's been very well put together, and the summaries. One reference said that only reporting is low across the community. One study that's not suggesting the Commission validated it, but it was just referenced. One study in this country suggested that only 10% of child abuse allegations, and I believe it was in New South Wales, but I'll be corrected on that, lead to a conviction, and only around half of those lead to a custodial sentence. I mention that simply to say that if on an occasion a victim of child abuse has felt that where Jehovah's Witnesses have taken a Bible-based stand, my heart also goes out to the thousands of victims who've come forward and asked for help. It's not resulted in a conviction, or if it has, only half of those result in a custodial sentence. So I just put it in the context that we are extremely aware of the damage that is done where the victim, it's compounded by the action that we, the police or the courts take, and in that context we absolutely agree with you.
I understand what you say, but can I just ask you this simple question? Why is it necessary when someone feels that they can no longer abide the organisation and has to dissociate, why is it necessary to shun them? Why can't they keep having social contact with those people who happen to remain in the organisation?
But I'd say again, and we're going to appear very repetitive, I apologise, Your Honour, but the individual can choose.
Why is it necessary for the organisation to tell all of its adherents, you must shun that person?
Because the individual has not taken the decision to no longer associate or to no longer be involved with congregation activities, which is their right. They've taken the decision to say, I'm shunning the congregation, I'm no longer a part of the congregation, I put it in writing. So the individual takes that action, and we understand the implications. When someone is disfellowshipped, the congregation takes that action. So the individual does not need to put themselves in a position where they're shunned. They can walk away, they can go to another congregation, takes that action. So the individual does not need to put themselves in a position of making, Your Honour.
Well, you haven't answered the point, but we'll move on.
Answer the question, Mr. Spence. You have not answered his honour's question. His honour's question is, why is it necessary to shun the person who disassociates? And before you answer, let me clarify one thing. The person who disassociates, both you and Mr. O'Brien have now said it, you said that they shun the organisation. They don't necessarily at all. You're talking about someone who just doesn't want to be part of it anymore. They still want to have their friends, their family, and everything else, their social network. So accept that kind of person, but it disassociates. Now, why is it necessary to have a policy that everyone else must now shun them?
Again, that's a decision the person makes, because that individual...
Sphinx, that is not...
Mr. Stewart, I don't think we're going to get anywhere. I think we should...
Well, the real answer to the question is because you say the Bible says so. That's the answer, isn't it?
Yes, that's our understanding of the scriptural disfellowshipping and disassociation doctrine.
I should just say also that in relation to the point that Mr. O'Brien, you made, and Mr. Sphinx as well, I think, and just say also that in relation to the point that Mr. O'Brien, you made, and Mr. Sphinx as well, I think, and that's that a person can become inactive without disassociating and in that way not be shunned. Now, without going through that evidence again, I just want to say to you that that's highly contested by a lot of people as to whether that is possible. I know you say that's the case. A lot of other people say it isn't.
I'm sorry, I misunderstood, but...
The simple point is, and I'll let you respond, but I'm not going to go down this path we went down it before. The simple point is this. A person who does not want to be active in the organisation anymore, in order to avoid being shunned, must disassociate. There isn't a category of membership of inactive and nevertheless welcome.
Sorry, Mr. Stewart, that's...
I know you disagree. That's
well,
fine.
when we've put it in print, I mean...
The only point I'm making is that that's not accepted.
Again, and I apologise, Your Honour has said we're repeating the point, but we have a very clear understanding of the difference between someone being inactive, no longer an active member of the congregation, and someone who takes a decision to disassociate. That's clear to us, but we agree to disagree.
Going on to the question of redress, you don't actually have a policy with regard to how to handle claims that are brought against the organisational claims made, not necessarily in a court, but someone says, look, I was abused in the organisation one way or another. I want compensation for this, so I want it to be dealt with. You don't have a policy that deals with that, do you? We're
certainly in the process of developing that, particularly since the release of the paper on redress from the Royal Commission. We've studied that and we're basically in agreement with many of the proposals in there. We don't take the view that we're waiting just until we hear the final thing, but there still are a number of questions that it seems to have to be resolved.
And that's this 2015 Royal Commission report on redress and civil litigation that you're referring to, is that?
Yes, that's right.
Okay, so that's been around for a couple of years now, but in short, you're saying you're working on a policy which we can expect at some stage?
Well, it's only in recent months we have had one request some time ago, probably more than a year ago, that we corresponded back with, and the claimant changed the solicitors they were using. So it's only just in the last, this week, the last few days, that we've received a report back from the...
Well, never mind individual cases. Can I just understand this from you? Is it the case that you're working on a redress policy and one can expect to see one in due course?
Yes, definitely.
Thank you. And has the organisation engaged with or reached a position on the Commonwealth Government's proposed national redress scheme that was announced in November last year?
No, not at this stage. Could I raise a question on this, which is of concern to us in being able to address this issue of redress, Mr. Stewart? Would that be acceptable?
Well, let's hear what it is, Mr. O'Brien, and then I can tell you whether we can answer it or not.
Okay, so with regard to the finding of the Royal Commission, with our bringing in all of the case files that we had, because of their being investigated, the finding was that makes all of them institutional abuse, even though the greater majority of them were not actually according to the terms outlined in the redress scheme as being institutional. So there's two implications for that I would see. One of them for us as an organisation, if the number of case files is the basis for determining maybe our share in a redress scheme, we would feel that would be not in the interest of being fair and adequate, because
You needn't worry about it. Your organisation came clearly within our terms of reference because we are required to look at the response of your organisation.
Yeah, which we don't contest.
And that response, of course, when inadequate, will cause damage to people. You understand that?
We understand, yes, that's a response.
And from the evidence that we've had, that is likely to have happened. You may not be an organisational abuser as such, but the response of your organisation may have compounded, indeed very much compounded, the damage to that individual. As far as the redress scheme is concerned, if it takes the form, or roughly the form the Commission has recommended, your liability will be determined on a case-by-case basis,
right,
and you will be contributing on a case-by-case basis.
Yes, so that's...
The files that we send off to the police, well, may or may not represent a part of your liability. I don't know.
Okay, so according to then the terms set out, I think it's on page 38 on the redress and civil liability, the recommendations, it outlined just what constituted institutional abuse. If that's as we understand it, then that would be something that would resolve some of the issues we have in our mind.
Well, you must understand, Mr. O'Brien, that this was the recommendation of the Royal Commission. This has now been taken up by the Commonwealth Government, and the government's in the process of consulting the states and territories and organisations, and how it will end up may be close or not so close to what was recommended. One doesn't know. So my simple question is to what extent is your organisation engaging in that process, or taking a position on whether it should engage in that process?
So at the moment, we haven't had any actual statement of claims, but we have had correspondence from 6 individuals. So we're formulating on the basis at the moment, still trying to determine what sort of extent of claims we would have, because I do understand from the report that each organisation would still be responsible for their own claims, which is part of the recommendation. If that was what the National Redress Scheme brought in, that possibly will affect which institutions and states would opt in for that. So I think it's still a little bit too unclear for us to commit ourselves definitively. We're still working through the process of determining just how we will handle redress.
You haven't ruled it out?
We haven't ruled it out, and we certainly, if there are any victims who are victims through institutional abuse from Jehovah's Witnesses, we would do everything in our power to assist them financially and spiritually.
And then finally, dealing with the question of the involvement of women in decision-making in the organisation, you're aware of the findings in relation to that. And finally, dealing with the question of the involvement of women in decision-making in the organisation, you're aware of the findings in relation to that. I won't repeat them. Your response is given tab 1, paragraph 7.5 and 7.6. So 7.5 is the broad statement. 7.6, you say women can and do participate in the process of presenting allegations of child sexual abuse to the elders. So I take it you mean that as a matter of ongoing practice that happens. Is that what you're saying, Mr. O'Brien?
This is to do again with the entire process of receiving an accusation, to the completing of giving support to a victim. So the role of women in the process, the only restriction that Jehovah's Witnesses have on that is in the actual judicial committee, which is dealing with the perpetrator, not dealing with the victim.
Yes.
So women can be involved in the entire process. The victim never has to confront the perpetrator, doesn't have to sit in on the judicial committee.
That's the point, isn't it? Your answer in relation to decision-making is that you are scripturally bound, that the decisions can only be made by men.
Yes, once again, that's a scriptural requirement that we adhere to.
And at the end of that paragraph, 7.6, you say, see paragraph 13 of the August 1 letter. I take it that's in support of the statement that complainant may be accompanied by a confidant, etc. That reference seems to be wrong because paragraph 13 at tab 7 doesn't say anything about that.
I might just get Mr. Spinks to comment on that. Is the expertise in the letter?
So, again, for the very reason you raised, Mr. Stewart, we've acknowledged that, and so in the current Australian safeguarding policy, and we've made the very recommendation that you've just raised. We've, if I can, the March 2017 child safeguarding policy,
Tab 11.
Paragraph number 10.
Yeah.
Says, again, the victim's never required to confront his or her alleged abuser. The allegation can be made in the form of a written statement. And then 2 sentences on, adults who were victims of child abuse may be accompanied by a confidant of either gender to provide them with moral support when meeting with the elders. So, again, it's a valid point.
I just want to come back to something I dealt with early on in case I didn't understand it clearly. This document you're looking at now, it's been approved by the branch committee but not yet finalised in case you want to make amendments following this hearing. Is that right?
We were ready to distribute it and made the observation that if something is said at the public hearing that needs to be clarified, then that's what we want to do. But our understanding at this stage is it's completed and subject to any other observations that we can include in it, but that's correct.
Right, so you anticipate then finalising it shortly. Would that be right? In the next week or two?
That's correct.
Yes. And then to whom is it going to be published exactly?
To congregation members.
To all congregation members.
So that's the audience for this document, is all congregation members.
How will that be done?
Well, that's the decision the branch committee has got to make, whether we're going to do that in a printed form or whether it's going to be distributed through electronically through the electronic mailing system for each congregation and made available locally. That's either way, it's available to all congregation members.
But you give the undertaking now that rephrase it, the undertaking now that the intention is that it be distributed to all congregation members.
Yes,
that's the audience for this document, and sorry, Mr.
yeah, I can speak on behalf of the branch committee on that. Who are authorised to make that available. That it will be available to every member of every congregation in Australia.
Well, making it available may be something different to what I'm speaking about, because making it available could be if someone asks for it, they can have it. I'm just seeking to determine whether it's actually going to be actively distributed so that people have access to it without having to ask for it.
So if I could, I'm not a part of the branch committee, but the recommendation that we've made, and I believe will be acceptable, that every congregation member will have it made available to them, whether that's through a paper distribution or an announcement or made available at the Kingdom Hall. That's the only decision that's got to be made. But every congregation member will be made aware of it and a copy made available to them in each of the 800 congregations around the country.
You'll understand and accept that to the extent that people's rights within the organisation are articulated in this document, they need to know what those are. And
absolutely.
Yes, I have nothing further on.
Mr. Tockley, do you have any questions? No, Your Honour, there's no regulation.
Before we close, I have one question. I want to refer you back to paragraph 1716 of tab 1. It's paragraph 716 of tab 1.
716.
What's on the screen is not that.
Joint statement.
Until 32.
I would summarise that as, in its totality, as indicating what we would describe as a pastoral response. Do you think that's an accurate description?
I don't understand the question. I apologise.
Well,
A religious response.
yes, pastoral means looking after the flock.
Yeah.
I mean, this is about empathy and compassion and so on. And that's all very well as it goes, but you would now understand from the Royal Commission's work that the often very grievous effects of child sexual abuse are life-changing and life-affecting, and therefore people need, and I stress independent, expert-independent therapeutic intervention, sometimes called counselling, but it can be better described as I put it. I want to know, in terms of your response to the 1,006 files of victims and subsequent victims that have come to your attention, whether the Jehovah's Witnesses branch in Australia have assisted or decided to assist or planned to assist victims or survivors with respect to therapeutic intervention by independent experts.
Yes, so on that, Commissioner, we, of course, allow the individual to decide who they would like to use, but certainly we will assist in funding any of the victims we fall into that category automatically under the terms of reference of the redress scheme. We would see part of the redress would be covering medical and ongoing psychological or psychiatric help or some other form of...
And you do that presently?
No, because we haven't had any actual claims or correspondence until this last mainly 6 to 8 months. And it's only just at the point now that the legal firm we're using, Gilchrist Connell, have now written to the solicitors of the victims and have now presented us with some suggestions for consultation.
Well, this is not really about the law. It's about going further than compassion and actually providing people help for grievous psychological harm. Surely you're not going to wait until 2018 when a redress scheme finally comes up to reach out to victims and survivors.
No, not at all, Commissioner, because we have already now been in contact with these, so the ones who've made claims, we're not actively going out looking for other victims because we don't know what the situation is with them, but those who've corresponded to us, who've sought some form of redress or compensation, we're at the point now where we can address that long before 2018.
Well, perhaps I could ask through you, Mr. Stewart. Perhaps I could ask through you if you could give us some formal advice as to whether you are assisting anyone at present with financial help for independent therapeutic advice as a branch.
We'll follow that up, Commissioner.
Nothing further? Nothing arising from that, Mr. Tockley?
No, there's nothing that should be done.
Very well, thank you. That brings this particular hearing to an end. And thank you both for your contribution, and you are now excused, and we'll adjourn until 2 o'clock.